Excuse me.
Oh yeah, go ahead. Oh, there's somebody was saying, excuse me. All right. So, how to live within contracts, understanding their essence and nature, the misrepresentation of UCCs by Taj Tariq Bey of the Moors of the Round Table. How to live within contracts. In our everyday life, affairs, and by way of most social and business activities, we are consciously and unconsciously being subjected to the obligations originating from contracts. We are constantly making, constructing, and motivated by contracts. Natural people are being bound by contracts or held obligatory, liable, or responsible to perform or produce by way of some form contract from time to time. And so we recognize that contracts may be social, personal, or national, etc. In many instances, the operative nature and the obligatory enforcement of a contract, real or assumed, may affect any one of us in one way or another. The effects of a specific contract may be positive or negative in character, and the outcomes and effects of the interrelational obligations established due to these contracts may be beneficial or injurious, positive or negative. Therefore, we should all have a conscious knowledge and awareness of fundamental contract law and know of the characteristics and conditions necessarily needed for determining their validity or invalidity. And so we extend these questions to the pertinent issues placed before you. What is a contract? What makes a contract valid, binding, and lawful? What makes a contract invalid, void, and unlawful? Too often, the nature and the required essence of contracts have not been properly taken into thoughtful consideration by many natural people. Therefore, the lawful conditions that must exist for a contract to be deemed valid and the proper legitimate construction of the same have not been taught to the people by those corporate state agents or agencies, i.e., government, schools, etc. Many people holding seats of authority have colorably abused the natural people and have economically benefited from the enforcing of invalid and void contracts at the peril of the misinformed. These opportunists prey upon contractual ignorance, groomed among the masses, and ignorance, which they have perpetrated for reasons of effecting constructive fraud, theft, arbitrary racketeering, legal abuses, personal gain, and for other deviant forms of deception, malfeasance, misrepresentation, and misprism. Some persons selling Uniform Commercial Code instruments, UCCs, or presenting other jurisdictional arguments and made on behalf of the corporate states. There are those who have implied that the natural people are deeply indebted to the corporate states because they have contracts that bind them to perpetual debt or servitude, etc. Some of those allegedly binding contracts are marriage certificates, birth certificates, social security cards, and driver's licenses, etc. I recognize that the ministerial judges, magistrates, prosecutors, policymen, and the like have colorably assumed jurisdiction over the natural people by way of such instruments. However, I respectfully submit this caveat. If the implied debt lawfully exists, then the said contracts must be lawful in their construction and in their original presentment. They too must be produced as evidence of the alleged debt and be measured by the laws that govern contracts. The unfortunate social and political reality is that the corrupt politicians have undermined the United States Republic for North America. They have been robbing the natural aboriginals of the land who have been subverted by organized political racketeers. The operative BMO governments of foreign law have been violating and usurping the Constitution and trampling on the unalienable rights of the people. They are boldly functioning under a color of authority through a foreign body politic at all levels, federal, state, city, town, and municipal governments, etc. The usurping body politic, which are criminals and usurpers, blatantly refer to themselves as the US democracy. Yet they are bound by official oath to support and defend the Constitution for the United States of America, which is by law a Republican form of government. Article 4, Section 4. Have a right to a Republican form of government. The Constitution and the official oaths are contracts. The Constitution and their official oaths are contracts. As for the alleged democracy form of government claimed by some of them, one body politic is constitutional and the other is not. By what contractual validity measurements are these facts or rulings determined? Let us now take a logistical look at contracts. Contract is derived from the Old Morse Latin word contractere or contractere and means to draw, to agree upon, to establish by agreement, to enter upon, and to undertake mutually an agreement between both parties. Contracts are essentially manifest, written, or oral agreements or covenants that are mutually entered into by two or more parties, involving or bringing the said parties into conditional obligations, which are enforceable by law. Contracts may be classified in accordance with the nature and elements that initiated their constructions, etc. A contract is thusly a promissory note or covenant made between the identified and competent parties. Competent parties. When you know trust law, one of the elements, all parties must be competent. Minorities can't even get into a contract or feel that that's in stone because they were a minority most of the time when they got into the contracts. And it's not valid because of that fact, because they weren't competent because they were a minority, because minority means to be incompetent, right? All right, so competent parties that creates, modifies, or destroys a legal relation upon sufficient and non-vague considerations. Considerations means something of value was made as a bartering tool for whatever services, whatever, which demands of a party to the contract to do or perform, or not to perform a particular thing. Upon the promise of obligations created by a contract, one side assents to the other. This is why a consciousness of the nature and essence of contracts are necessary elements of everyday living and demonstrative of why all must be diligent in our social, personal, and national affairs. Thus, we must be aware that a valid and lawful contract must demonstrate the following. So the following are examples of valid and lawful contract elements. A valid and lawful contract must meet the following criteria. A contract must show in its preliminary making and construction a clear and substantive offer made by one party and demonstrate the mutual acceptance affirmed by the other party. B, a contract must be producible and exist in evidence upon demand made by either party to the contract, which in itself may be in question, dispute, or controversy. C, a contract must be produced in manifest writing, evidence, and contain the details of the agreements, debts, promises, right? They got to produce these things with all the terms and obligations and the conditions which clearly show and serve as proof that a valid and enforceable obligation, promise, or debt exists. D, A contract must be deliberate and conscious agreement made between competent parties. Once again, between competent parties, a conscious agreement, nothing backhanded. E, a party to a contract cannot be a minor. F, a contract must be entered into by free will. G, a contract must not be created under threat, duress, or coercion, lest it be void in law. H, a contract must be substantive and germane to the subject matter. I, a contract must be of a legal consideration. It cannot be based on unlawful consideration. Once again, consideration. You look that up. That's something to value. J, a contract must possess mutual agreement and mutuality of obligation. Everybody got to be on the same page what the obligation is. K, a contract must not be vague, unclear, uncertain, nor can it contain terms or conditions that are not ascertainable. L, a contract must show valid signatures of the parties to the contract instrument in order to verify its validity in law. All parties involved in the contract need to have wet ink signatures. There's 3 parties involved, and you see 3 signatures. It shouldn't just be 1 signature, and there's 5 parties involved. That's fraud. That's called a linear contract. And that's a violation of contract law. It's not a contract when that exists. Islam Mahmoud, happy holy day.
More. Islam. No.
So note, if a contract fails to satisfy the laws that govern its making or construction, then any such contract is void ab initio, or on its face, or in its inception, and is considered dead in the view of the law. We also want you to become familiar with some of the varied forms of contracts so that we can work towards being more aware and astute in our social and political affairs. Research these during your culture, law, and history classes. 1, certain and hazardous contracts. 2, communicative and independent contracts. 3, express and implied contracts. 4, mutual interest and mixed contracts. 5, fair and reasonable contracts. 6, constructive contracts. 7, consensual and real contracts. 8, conditional contracts. 9, divisible and indivisible contracts. 10, executed and executory contracts. 11, gratuitous and onerous contracts. 12, joint and several contracts. 13, pre-contract. 4, parole contract. 15, a personal contract. 16, a principal and accessory contract. 17, a subcontract. 18, a special contract. 19, quasi-contract. 20, record, simple, and specialty contracts. 21, unconscionable. I got dyslexia right now.
Unconscionable.
Yeah, but basically that means it can't be contracted. Because conscionable, I can't talk right now, but that word means it's a valid contract. If it's unconscionable, it's not a valid contract. 22, unilateral and bilateral contracts. Once again, unilateral will be not contractable, because unilateral just means it's one signature on something, or it's just one-sided against one party.
Yeah,
multiple people got to be
this is
at
a
risk.
unilateral contract.
Yeah. Not just a minor in this case. Unilateral just means it's just one signature. And it's except there's 3 parties involved, and all of it's on you. Like you just signing everything, but none of the other people got their signature on the bottom. That has to take place for it to be valid, right? And then you got bilateral contract, right? 23, usurious contracts. 24, Written contracts. 25, contract of sale. Remember, never accept legal instruments from the corporate state without cross-checking their presentments. Remember that for the most part, they are operative feudalists, feigning as legitimate constitutional governments. Their color of law activities have already proven them unworthy of trust or honor. Therefore, when dealing with the corporate state employees and quasi-government pseudo-officers, always measure their actions by Constitution principles. Protect yourself from their bureaucratic and institutionalized fraud whenever possible. So what is fraud? Fraud is an intentional perversion of truth for the purpose of inducing another and reliance upon it to part with some valuable thing belonging to him or to surrender a legal right. It is a false representation of a matter of fact, whether by words or by conduct, by false or misleading allegations, or by concealment of that which should have been disclosed, which deceives and is intended to deceive another so that he shall act upon it to his legal injury. In case law, Bernard Dispatch Newspaper Company versus Froween County is case law dealing with those elements of fraud. Fraud is any kind of artifice enjoyed by one person to deceive another. Goldstein versus Equitable Life Assured Society is another court case dealing with that aspect of fraud. Fraud is a general term embracing all multifarious means which human ingenuity can devise and which are resorted to by one individual to get advantage over another by false suggestions or by suppression of truth, and includes all surprise, trick, cunning, dissembling, and any unfair way by which another is cheated. In that case law, Johnson versus McDonald, cross-reference to what I just read right there. Bad faith and fraud are synonymous and also synonyms of dishonesty, infidelity, faithfulness, perfidy, unfairness, etc. Joyner versus Joyner, dealing with bad faith issues. Administrative law and administrative judges. Administrative law is that body of laws created by administrative agencies in the form of rules, regulations, orders, and decisions. Administrative law judges are hearing officers or hearing examiners established by Administrative Procedure Act 556. These are officers who preside over administrative hearings with power to administer oaths, to take testimony, to rule on questions of evidence, and to make agency determinations of fact. Politically, and as used in constitutional law, administrative officers are of the executive department of government, and generally one of inferior rank. And legally, a ministerial or executive officer is distinguished from a judicial officer. So it's a difference between a magistrate and a judicial officer, right? Or a ministerial judge. On the other hand, a judicial officer is a judge or magistrate. This fiduciary, which fiduciary just means trustee, this fiduciary title and position applies generally to any officer of the court, but in a stricter legal sense, this position applies only to an officer who possesses the authority to determine cause between parties or who renders decisions in a legitimate judicial capacity, having the vested powers to decide causes or to exercise powers appropriate to the court. There is a clear distinction in law between administrative officers and true and authorized judicial officers or judges. When acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. Courts in administrating or enforcing statutes do not act judicially, but merely ministerially. Court case Thompson versus Smith. that was ruled upon. A judge ceases to sit as a judicial officer because the governing principle of administrative law provides that the courts are prohibited from substituting their evidence, testimony, record, argument, and rationale for that of an agency. Additionally, courts are prohibited from substituting their judgment for that of the agency. Courts in administrative issues are prohibited from even listening to or hearing arguments, presentation, or rationale. ISIS versus US. Ministerial officers are incompetent to receive grants of judicial power. So they're telling you that these people aren't even competent to be lawful officers. They, like I said, when you go through the municipalities, you start blazing on with some law, some jurisprudence. Watch how the eyes start opening up, they start sweating, and you know what I mean, stuff like that. Recess, can we come back? You know what I'm saying? And it's because they have no power. They have no duty. They know that these municipal courts know that they're not Article 3. It's not a secret. It's just the people don't know law, so they didn't got cocky in their position. That's the bottom line. The elementary doctrine that the constitutionality of a legislative act is open to attack only by persons whose rights are affected thereby applies to statutes related to administrative agencies, the validity of which may not be called into question in the absence of a showing of substantial harm, actual or impeding, to a legally protected interest directly resulting from the enforcement of the statute. And that's Board of Trade versus Olson. Jurisdiction is the power conferred by the Constitution or by law. The courts charged with adjudicating matters stemming from the violations of these administrative statutes, rules, and regulations lack jurisdiction in personam. Jurisdiction in personam over sovereign Moorish American men and women. The federal and corporate state courts are aware of this want of jurisdiction. However, they will not freely admit to their lack of authority or to their lack of ethics and integrity. This goes to the pit and inner. Most recesses of judicial corruption and racketeering in North America. It is essential that you have a clear understanding of the fact that jurisdiction in personam must be challenged, or the court will arbitrarily presume or assume jurisdiction over your person and may thereafter prosecute the matter against you to your legal, economic, and or bodily injury or abridgment. Therefore, there are many ways for you to waive jurisdiction and permit the court to proceed. Know that they are always seeking ways and methods of fooling you or intimidating you into allowing them to claim jurisdiction. You must be forever diligent and never waive any of your unalienable rights or constitutionally secure rights, regardless of the appearance of a convenience of doing so. You have no legal nor moral responsibility to waive your rights merely for the colorable conveniences of the courts. Always remember that the court system is supposed to belong, and tedious as due process is supposed to be difficult for the adjudicators and the courts to overcome. Do not ever under any circumstances make it easier for the government, the adjudicators, or the courts to prosecute you. Always take into consideration that the Constitution and the 10 amendments are 10 Bill of Rights. See, we had 10, that 10 number, everything after 10 is fraud, which comprise the Bill of Rights, make challenging the jurisdiction of the court one of the best and entrenched among the good habits that you never try to intend to break. 1, jurisdiction in personam refers to jurisdiction over the person and involves the power to subject a person or parties in a particular case to decisions and rulings made in such a case. It is one of the 3 kinds. Jurisdiction is the power of him who has the right of judging and involves the authority, the capacity, and the power or the right to act. Jurisdiction also relates to the judicators and the courts, judges, magistrates, etc., and exists with the court, has cognizance of class, of cases involved, when the proper parties are present, and when the point to be decided is within the issues. The burden of proving jurisdiction for the record remains at all times upon the judicators of the court, upon the challenge made by the alleged, accused, or defendant. 2. Jurisdiction of subject matter refers to jurisdiction of a particular class of cases in law and of attending subject matter relative to the class to which the case belongs. So, subject matter is a class of law, and it's case law to coincide that fact. So we're saying subject matter, we're talking about, like I say, is it an injured party? They can't move past that. Like anything where it's not an injured party is an example of they've yet to show you how they got subject matter jurisdiction.
Delegation of authority.
You know what I mean? Right. They
Where
have,
you derive it from.
and you know what I'm saying? And all matters dealing with diversity of citizenship, it's not an Article 3 court. It's an inferior court. They don't have subject matter jurisdiction. And they gotta produce it. 3, jurisdiction to render particular judgment, which was given. The capacity of the judge to have power to render decisions. So that's back to Article 3, Section 2. Like if it's an inferior court and there's no delegation of authority on the wall, then they don't have delegation of authority. You know what I mean? It's not even a real court. Consider and study the following types of jurisdiction: appellate jurisdiction, concurrent jurisdiction, contentious jurisdiction, coordinate jurisdiction, criminal jurisdiction, excessive jurisdiction, exclusive jurisdiction, foreign jurisdiction, general jurisdiction, limited jurisdiction, pendent jurisdiction, probate jurisdiction, special jurisdiction, summary jurisdiction, territorial jurisdiction. Now we're dealing with land, right? Territorial. And voluntary jurisdiction. Most things are voluntary. People don't know what they're doing half the time. A contract founded on a base consideration or against good morals is null. Null. Base in law means that which is low, inferior, foul, servile, of a subordinate degree or nature, impure, and unadulterated, or alloyed. Null is a term in law which means naught and being of no validity or effect in law. Null is usually conjoined with the word void, as null and void. In the law that governs contracts or statutes, null and void is used, applied, ruled, or recognized to establish, declare, or proclaim that such a low, inferior, foul, servile, or base claim, claimant, judgment, summons, ticket, bill of exchange, or that of any other contractual instruments befitting for the nature of the foresaid descriptions are dead in law, colored, fraud, non-binding, unclean, and having no legal force of effect. Keep this concept of right, law, civics, knowledge in mind whenever someone says to you, you've got a lot of contracts out there. You are bound by them unless you make new contracts and file them with the state in order to dissolve or destroy these contracts because they give jurisdiction over you to the corporate states and are their quasi-government agencies, employees, and contractors who are seeking to cause you to be bound by some veiled straw man debt and are thereby authorized by such to assume jurisdiction. to have lawful right to cause you a legal tort, imprisonment, or injury. Any officers of the courts or persons or employees or entities exercising any authority whatever in the United States or in any of the several states or holds any office of public trust under them or under any of them shall be bound by oath or affirmation to support the Constitution for the United States. All officers of the courts and all executive, legislative, or judicial officers of any persons, personnels, employees, contractors, associates, agencies, or any others who function or operate under their authority or employ shall be bound by that same supreme law of the land, the Constitution. The Constitution for the United States is the supreme law of the land, by which the judges and all other officers of the courts are bound. They must be ever cognizant of their fiduciary or trustee duties and never violate, supersede, or abridge their limited, delegated authorities, and with the Constitution contract ever present in the exercising of their offices, always hold true themselves and their offices to the high standards of integrity and ethical behavior, as sworn to or affirmed by them by solemn oath, and as befits the public trust vested in them. Any authority exercised by or any decisions made by any judge or any officers of any courts under the authority of the United States Republic or claiming to be a party in any controversy to which the United States or to which any of the several states in the Union with the United States as a party are bound by official oath as per Article 6 of the Constitution. Any judge or any other officers of the courts who uses or exercises any authority not vested in them, or who uses or exercises any authority not vested in the officers held by them, are acting under color of law and are exercising color of authority, which is a violation of the public trust. In such cases of violations, the public trust that said judge or any of the said officers of the courts or any employees or personnel functioning under them are perpetrating a supreme, active, and constructive fraud upon the people of the United States and are in enmity to the Constitution. They shall be deemed void of authority and are criminals by being a party in such an unconstitutional act. They are then acting upon their own personal or foreign interests and with non-authoritative intent, and are guilty of acting under a color of office. Any judges or officers of the courts who act upon decisions or orders issued by any such violating judges, officers, persons, agencies, or entities in association with them are in conspiracy with them. And the principal of the said conspiracy is a guilt party. And the agents to the principal actors are also guilty and held as participants in collusion with them. Contractual instruments and warrants or orders issued from violators of the Constitution and any actions enforced or entered into or acted upon by way of these unlawful instruments, contracts, shall never be valid or lawful. In the laws of the governed contracts, there cannot exist base consideration. For if any instance the aforesaid base considerations exist or can be demonstrated, then that contract remains unlawful and non-binding from its inception and from its beginning. It is as if never existed. The obligations implied by or debts commanded by any unclean or allowed contract or any power of attorney or power of attorney assumed by anyone upon such an instrument is a severe penal violation and is unclean and foul and null. All claims of jurisdiction or contracts issued under the assumed powers of jurisdiction are subject to the laws governing contracts. They are subject to the laws governing contracts. Contract law. Once again, everybody look up contract law. That's a body of law. And are subject to the remedies put in place by law to punish such persons who engage in such colorable activities. Research United States codes of law that are related to such colorable actions, such colorable violations, such as Title 18, Part 1, Chapter 13, Section 241 of the United States Codes. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise of enjoyment of any right, privilege secured to him by the Constitution of the United States, or because of his having so exercised the same, or if two or more persons go into disguise on the highway or on the premise of another with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping or any attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title, or imprisoned for any term of years, for life or both, or may be sentenced to death. So we just read Title 18, which talks about anybody that's violating your constitutional secure rights, anybody intimidating you or discouraging you from your constitutional secure rights. Federal court lawsuit under Title 18, Part 1, Chapter 13, Section 241 of the United States Codes, dealing with deprivation of rights under color of law. Title 18, Part 1, Chapter 13, Section 242 of the United States Codes of Law. Whoever under the color of any law, statutes, ordinance, regulation, or custom willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being an alien or by reason of his color or race, are prescribed for the punishments of citizens shall be fined under this title, or imprisoned not more than 1 year or both. And if bodily injury results from the acts committed in the violation of this section, if such acts include the use of attempted force or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years or for life, or both, or may be sentenced to death. Therefore, in preservation of the rights of the people, and in support of their unalienable rights and affirming their Constitution secured rights, we present this small literary script. The natural people have and possess by nature's law the rights to be secure in their persons and in their properties or papers, etc. Government exists for one purpose and cause only, and that is to secure such rights. The people have the right to not be abused by or deceived in the courts of the United States. The people are not to be bound by nor to be held subject to colorable or null contracts, nor wrongfully adjudicated in, nor ruled over by mere ministerial officers pretending to possess judicial authority. When the natural people are abused by or summoned into court by any non-Article 3 court administrators, know that such persons are acting by a color of authority. Always think, suit, suit, suit. Measure judges and all court officials by the limited authority vested in them. Measure and judge all contracts by constitutional principles and analyze them by the contract qualification laws that govern such instruments. Study contract law. Once again, simple Google search. Contract law. What are the elements of a contract? Always hold the corporate state parties, court officials to the high moral standards as prescribed for them by the sworn or affirmed oaths taken by them, and in accordance with the constitutional obligations taken by the oath-bound officers of the courts, consider that when any administrative officer claiming to be a judge imposes himself into jurisdictional venues or matters wherein he possesses no lawful judicial powers and thus lacks jurisdiction, then demand a dismissal of the case. There are no lawful pleas to be made before such a non-sanctioned and unlawful court, nor are there any lawful pleas to be made before the unlawful officers of that court. Such an act constitutes a waiver of jurisdiction, which cannot be lawfully done or claimed by either party. This warranted condition presents in law a circumstance wherein a most vile criminal was presiding as judge over an alleged accused or implied criminal who has not yet been found guilty impartially or by a jury of his own peers, his or her own peers. There are no greater crimes crafted against humanity than that of inferior and non-judicial officers in government who have no honor or integrity, who lack jurisdiction, and who willfully exercise such powers vested in any of the offices of public trust, not resting with them, and using such powers against the interest of and to the injury of the people. The natural people possess by divine law and by nature's law the rights to life and to living. Living means having life and being active and functioning, exhibiting the life or motion of nature, and having the means of subsistence related to livelihood. This is a basic right and is protected and preserved in any civilized society. Conditions are ancient in their character, and existence. They are in place to secure the basic human rights of people from the evil and vile machinations of the uncivilized beings who tend to corrupt society. A scholar or neophyte is encouraged to do an expanded study and review of these conditions of jurisdiction. You must always study the forms or types of contracts in order to gain further clarification on the subject matter. Once again, you must also study the forms or types of contracts in order to gain further clarification on the specific character, the nature, and the relative elements of jurisdiction and contracts. All right. So hopefully people learn something today about contract law. What makes a contract valid? Why contract's not valid? What consideration is, right? A minor can be a party to the contract, can't be unilateral, can't be one-sided, right? It's things that need to stick in our mind. Consideration, everybody should look up consideration. That's contract law talk. Consideration. These are law terms in contract law. If there's no consideration, it's void. So peace and love, Islam. And it's just, I'm gonna stop recording. All right, so thoughts on the literature that was read.